All right, everyone, and in this short case reading video, we're going to be looking at the Ringrow case. So I will just share my screen with you. Yeah, okay. The drop-down menu comes, and then I can't click on slideshow. I've got it. All right, let's do it. Okay, so the Ringrow case, so Ringrow and BP Australia, which is to do with that purchase of the service station and the company that then chose to buy their petrol from someone other than BP, okay, and then BP then exercised a right they had under the contract. And the question was whether their exercise of a right they had under the contract to repurchase the property, whether that was actually a penalty. So in this case, rather than look at, a liquid damages award per se, so it's rather than looking at that pre-specified loss in the contract, it's whether other clauses can also be a penalty and therefore unenforceable. So it's a sign. So in terms of this case, as mentioned, Ringrow entered into an agreement with BP for the purchase of the service station. A collateral agreement required Ringrow to purchase fuel from BP exclusively, and also enabled BP to buy back the service station if there was a breach of this agreement. And what that meant was that quite a trivial breach of the agreement could trigger that clause and allow them to buy back the service station. Ringrow bought the service station, and then they were using fuel from another supplier. And then BP attempted to exercise the option under the contract. So they attempted to buy back the service station. Ringrow claimed that the option was a penalty, and therefore that it was void and unenforceable. And interestingly, in this case, there was actually a liquidated damages clause. So if BP didn't exercise their right to take back the service station, they actually would have been entitled to liquidated damages under a liquidated damages clause. But that clause itself wasn't the one that was argued to be a penalty here. It was that clause around them taking back the service station because of even a trivial breach. Okay, all right. Now in this case, it was ultimately held in terms of so in this case they talk through this doctrine of penalties, and they talk through when one of these clauses, so either a liquidated damages clause or an alternate clause such as this one here, talk through the principles around when they'll be considered to be a penalty. Now, while the case affirmed the relevance of key cases such as Dunlop Pneumatic Tyres, which is one of the older authorities, while it still affirmed those cases to the penalties doctrine, it actually took a slightly different approach. So in Dunlop Pneumatic Tyres, it was held that when one of these clauses is a genuine pre-estimate of loss, then it won't be a penalty. So the focus was on, I guess, the amount potentially of a liquidated damages clause versus the amount of damages that would potentially be recoverable for that breach. So that was kind of the key focus. Whereas this case, shifted the focus a little bit from that to looking at whether the amount stipulated or the clause itself is out of all proportion with the loss likely to be suffered. Okay, so this calls for something extravagant or unconscionable. So it kind of has that higher threshold then for establishing that something's a penalty than just focusing on that genuine pre-estimate of loss. Okay, it'll make more sense in a moment when we go through the different case reading questions. Anyway, so the case itself stated some of these principles around penalties. Now, in the dot points here, I also have that, so there must be that extravagant or unconscionable difference between the damages and the damages that would be awarded for breach of contract. Okay, it needs to be out of all proportion, okay, as opposed to just purely disproportionate. It needs to be out of all proportion. So that higher threshold, and have that oppressiveness dimension. And also with regards to the clause at issue in this case specifically, the fact that an agreement can be terminated for a minor or technical breach, okay, doesn't mean that the penalty doctrine is automatically triggered. So the fact it seems a little bit unfair that a clause like this could result in this, not a clause like this, a breach like this, so buying petrol from someone else could result in the loss of a petrol station. That's not the centre of the inquiry here. Okay, so you've got to look at the clause itself, and then you look at whether that clause is out of all proportion with the loss likely to be suffered. Okay, so yeah. All right, we'll go through the case reading questions. All right, so in terms of our first question here, so what did the parties agree BP was entitled to in the event that agreement was terminated before the end of its 5-year term? Okay, here the parties agreed that there was that option to repurchase the site on behalf of BP. So they could essentially take back the property or repurchase it, not just take it, have to pay for it too. All right. In terms of the second question, on what basis did Ringrow challenge BP's intention to exercise its option to repurchase the service station? They challenged it on the grounds that it was a penalty. Okay. Now, this question 3 here goes to that doctrine of penalties more generally. So question 3, so what test did the High Court say expressed the law applicable in Australia on penalties? Okay, so the High Court did confirm the relevance of the test in Dunlop and pneumatic tyres, which is essentially that the clause will be a penalty if the sum stipulated is extravagant and unconscionable in amount in comparison with the greatest loss that could conceivably be proved to have followed on from the breach. But as I mentioned before, since Dunlop, there had been more of a focus on whether the clause was a genuine pre-estimate of loss, and that is still relevant here. However, Ringrow really did emphasise that level of, the amount has to be out of all proportion with the loss likely to be suffered in the event of a breach. Okay, so it's a little bit more of a focus on whether it's out of all proportion as opposed to whether the clause itself, roughly estimated the type of loss that would be applicable or would happen. Okay. All right. So number 4, does the doctrine of penalties apply in principle when the parties agreed to a transfer of property as distinct from a payment of money on breach of contract? Yes. Yes, this case shows that it does. So here it wasn't contested by BP that this doctrine of penalties is applicable to this type of clause, even though it's not a traditional liquidated damages clause in the sense of specifying the amount to be paid on breach. It was, the fact the property would go back to them or they'd have that option to purchase it. And the High Court actually says in the case that there's authority to support that the doctrine of penalties doesn't just apply to those liquidated damages clauses where the amount is specified. It also encompasses circumstances like this where parties have agreed to a transfer of property. Okay, so it wasn't a live issue in this case, but the High Court did confirm that the doctrine of penalties applies to these types of clauses. All right, so in terms of the next question then, it was argued by Ringrow that a provision for payment of a liquidated sum or transfer of property would be a penalty if it was not proportional to the amount of actual loss caused by the breach. What was the High Court's response to this argument? Okay, the High Court gave this argument very short shrift. It was essentially just flat out rejected. So there is no requirement of proportionality. The test is whether it is out of all proportion, okay? And then in terms of the next question here, so what did the court say has to be shown before such a provision will be regarded as penal? That the amount is extravagant and unconscionable in amount. So not only it isn't about it being proportional to the loss likely to be suffered, for it to be a penalty, it has to be extravagant. So that gap has to be bigger, if that makes sense. In terms of question 6 here, what policy ground is advanced by the court for allowing the parties great latitude in agreeing on compensation for breach. In terms of that one here, this really just comes down to freedom of contract. Okay, so the parties are allowed to contract in the way that suits them. Okay, all right. In terms of number 7 here, so did Ringrow show that valuable goodwill attached to the BP Lansdale site? No, they didn't actually lead any evidence around this, which then obviously inhibited that inquiry into whether the effect of the clause was out of all proportion to the loss likely to be suffered. Okay, so the court actually couldn't do that comparison that they needed to do to be able to show that it was a penalty. Okay, so that evidence wasn't led. In terms of the next sub-question here at number 7, if it had have shown that the value of goodwill was significant, do you think the court might have concluded that the provision was penal? The answer to that is yes, because they would have actually been able to do the comparison. And if that difference between the clause and the effect of the breach, if that had have been compared, and the difference had have been extravagant and unconscionable, then that argument around penalties might have succeeded. Okay. Now, in terms of number 8, then, Ringrow did not suggest that the agreement for liquidated damages for breach of the collateral agreement around the petrol was penal in nature. So as mentioned, there was actually a liquidated damages clause in this contract. However, this argument around penalties applied to the other clause, okay, the one about them being able to buy back the site. Just reading the second half of question 8. So can you see why this provision would be regarded as a genuine pre-estimate of actual loss resulting from the termination? In that instance, I think there's a good reason why they didn't argue that that clause in particular was a penalty, and that's because it was based on an assumed financial benefit to BP over the 5 years. So it wasn't a random, extravagant figure plucked out of the air. It was actually, a figure that had some grounding in the facts and the likely losses to BP in terms of that time period. Okay, yeah, so I'll finish there. We'll discuss